legally valid. If not, the doctor will be liable under the tort and criminal laws. The law presumes the doctor to be in a dominating position. Hence, the consent should be obtained after providing all the necessary information. In this instant, the appellant is not incapable of giving consent, and she has clearly notified her doctor before itself to not operate. Hence, we can clearly say that there is gross negligence on the part of the hospital authorities by not obtaining her consent or her husband's. If the Honorable Court permits, the counsel for petitioner would like to cite a case of similar nature. If we look at the case of Samira Kohli versus Dr. Prabha Manchanda from 2008, the Apex Court held that the consent given for diagnostic and operative laparoscopy and laparotomy, if needed, does not amount to consent for a total hysterectomy with bilateral salpingio-oophorectomy. And this case proves that the consent is the first and foremost pillar in medical treatment and the world of medicine. The question was not about the correctness of the decision to remove reproductive organs, but it was a question about the failure to obtain consent for removal of the said reproductive organs, as it amounts to an unauthorized invasion and interference with the appellant's body. Now, coming to the fourth issue raised by the petitioner, whether the appellant is entitled for compensation as claimed or not. With due permission from the court, the counsel for petitioner would like to cite two cases where the appellant was entitled for compensation as claimed in very similar cases. The first, Lakshmi Rajan versus Malar Hospital Limited. The complainant was a married woman who noticed development of painful lumps in her breasts. The hospital's doctor, while treating the lumps, removed her uterus without justification. The opposite party was directed to pay rupees 20,000 as compensation. The second case we would like to cite is of C. Sivakumar versus Dr. John Arthur. The plaintiff had the problem of blockage of urine, and the doctor, in an attempt to perform the operation for curing the problem, totally cut off his penis. The plaintiff became permanently impotent. It was held to be a case of deficiency in service, and the defendants were held liable to pay compensation of rupees 8 lakhs to the plaintiff. Now, I would like to hand over the case to my second speaker, Yukta.
As stated before by the counsel, I, Yukta, will be raising issue 2, which is whether the complications regarding infertility were explained prior examination to Ramita Bindra, whether the doctors did not respect her right to reproductive autonomy. Another issue in this case is that it was assumed that the petitioner, being a young, newly wedded woman, wanted to preserve her fertility, and the doctors made their decision during examination that the tumor has to be operated on in order to preserve the patient's fertility. Ideally, when the patient has adamantly refused a surgery, the doctors should have discussed the issue with the patient on grounds of fertility after the examination was done, and then performed surgery if the patient has given consent. Also, it was stated by the Supreme Court in the case Suchita Srivastava and another versus Chandigarh administration that reproductive autonomy is a dimension of personal liberty as guaranteed under Article 21. It held it is important to recognize that reproductive choices can be exercised to procreate as well as to abstain from procreating. A crucial consideration is that a woman's right to privacy, dignity, and bodily integrity should be respected. The doctors were in no state of making this decision for the patient as the surgery was not carried out in an emergency situation. It is clear from the above arguments that the patient's reproductive and sexual rights have been impinged.
As stated by my counsel member earlier, may it please the court, I, Samyukta Venkatesan, would like to raise the third issue, whether Meera Devi Hospital violated the fundamental right to life under Article 21 of the Constitution of India by performing surgery that caused post-surgical effects on Ramita Bindra. So, right to life is fundamental to our very existence, without which we cannot live as human beings. And this includes all aspects of life, which make it meaningful, complete, and worth living. And all the other rights add quality to the life in question and depend on the pre existence of life itself for this operation. Thus, the bare necessities, the basic requirements of a person form the core concept of right to life. Article 21 talks about the protection of life and personal liberty. The hospital had failed to protect the life of my client. When I say life here, I mean something more than the mere animal existence. The inhibition against deprivation extends to all the limbs and faculties by which life is enjoyed. And in the case, I would like to cite a case. In the case of Francis Corelli versus the Union Territory of Delhi, it said that such a deprivation is lifelong and it is not complete once and for all. So, as long as it lasts, it must be within the inhibition of Article 21. The surgical complication of the procedure that Ramita Bindra had not consented to led to complete amputation of her fingers, inhibiting her entire ability to lead a healthy livelihood in this state and caused permanent disfigurement to her body and mind. And amputation itself can cause psychological effects. It can cause mental agony, decrease self esteem, social isolation, increased dependency on the partner, dysmorphia, all short and long term effects. And regarding the second clause of Article 21, personal liberty. So, in any medical procedure, a patient can either consent, has the right to consent, or the right to refuse. And Ramita Bindra, as the statement of facts, she had adamantly notified the doctors that she did not want surgery. Ramita Bindra was a young woman, mentally sound, and well capable of taking decisions on her own body. Thus, acting against the patient's direct wishes violates their bodily autonomy. There's a clear breach of informed refusal here, and the patient's right to determine whether what treatment to undergo was not respected by the doctors. And performing the surgery was a direct infringement of patient autonomy. I would like to go through the conclusion of the cases. So there's lack of communication and empathy from the hospital, and this acts as the precipitating factor for any medical legal suit. And to standardize this practice, the Medical Council of India and the Constitution of India has set out certain guidelines in which it states that consent has to be obtained before any operation. So consent has now become a very important ingredient of our medical practice. Examination of a patient, any therapeutic intervention, treatment, surgery, consent must be obtained. And if the Honorable Court is satisfied with our issues raised and the arguments, the Council would like to move on to the prayer. Wherefore, in light of the facts presented, issues raised, arguments advanced, and the cases cited, the Council for the Appellant humbly pray before this Honorable Court that it may be pleased to set aside the judgment of the District Court and award compensation which is just, fair, and reasonable for my client, or pass any other order or directions the court may please and deem fit to the interest of justice, equity, and good conscience in this instant case. With this, the Council rests the case. Thank you.
So thank you very much, Team Simsa.
Okay. If Team Simsa is done, we'd like to have the Team Simsa yield to the jury. The jury, would you like to offer any questions to Team Simsa for their presentation? Okay, so I think we can go on for the defendant's side now. Is team MSAI ready?
Hello. Yes, Riya from MSAI. Am I audible?
Riya, we can hear two voices.
Okay. Yeah. Better now?
Yeah. Can I please check my mic as well? Am I audible?
Yes,
Am
Pankaj,
I
you're audible.
audible as well?
Yes, Kritika.
Thank you.
Yes, Kritika, you're audible. Yes. So, team MSA, are you ready?
I think,
So,
Riya, can you hear us?
Yes, we are.
Okay.
okay. So, I'll start the timer in 3, 2, 1.
Greetings
The time
to the
has begun.
honorable,
Please.
Okay. Greetings to the honorable jury, counsels for the appellant, members of the court. As the counsels for the respondents in Mrs. Ramita Bindra versus Meera Devi Hospital, we would vehemently oppose all claims of negligence against our client, Meera Devi Hospital. We, on behalf of our clients, would contest our claim on the ground that the matter involved complex and intricate questions of medical science and technology. The difficulty faced by Mrs. Ramita Bindra is purely a medical hazard as a result of a complication accident during necessary actions that needed to be taken in the best interest of the patient. Hence, I would like to start my arguments with the first issue to be raised, whether my client's decision to resect the tumor without consent was in the best interest of the patient. Was it an act of beneficence and non-maleficence? And if yes, would it amount to negligence? So I would like to start off my argument by stating the Hippocratic Oath. It states that I will use treatment to help the sick according to my ability and judgment, but I will never use it to injure or wrong them. The oath obliges the physician based on his ability and the judgment to benefit the patient. This is the principle of beneficence, the first pillar of bioethics. The oath also places on the physician the obligation to not to harm the patient. That is primum non nocere. This is the principle of non-maleficence, another principle of bioethics. Beneficence involves balancing the benefits of treatment against the risk and the cost involved, and non-maleficence states that the medical practitioner has the duty to do no harm or allow harm to be caused to a patient through negligence. In the light of these statements, with respect to my case, the fibroid tumor was diagnosed by my client using a standard diagnostic procedures applicable for a fibroid. My client decided to do a surgical examination in order to confirm the severity of the tumor, the grading of the tumor, and accordingly decide the treatment. During the surgical examination, it was clear to my client that if not resected, the tumor could result in further complications, which could be life-threatening to the patient in the future, and most importantly, could render her infertile. Here, I would like to state that fertility is something that is normal in a human being, and to preserve it is an act of beneficence. The surgery itself does not have any complication. The surgery does not involve removal of hysterectomy, removal of the uterus. My second point being, it gave the surgeon the opportunity to remove the tumor within the same surgery, thus avoiding a second surgery, the burden of anesthesia, and the cost associated with it. It is always better to avoid multiple surgeries, to avoid invading the body of the patient multiple times. There are no specific risks associated with this surgery except the standard complications associated with any surgical complications, a surgical procedure. Thus, in this case, the benefit of the surgery outweigh the harm by a very huge margin. Hence, my client made a decision in the best interest to preserve her fertility and prevent future complications, thus abiding by the principle of beneficence. The doctor's primary intention was to save his patient from any harm caused by the tumor and nothing otherwise, hence abiding by the principle of non-maleficence. To support my argument, I would like to state the following. Section 92 of the Indian Penal Code states that any act done in good faith for the benefit of a person cannot be concluded as an offense by reason of any harm which it may cause to a person, for whose benefit it is done in good faith. Section 81 of the Indian Penal Code states that if anything is done which is likely to cause harm, but if the same is done without any intention to cause harm in good faith in order to avoid any other damages to a person or his property, is not an offense. And Section 88 also says that no one can be accused of any offense if he performs an act in good faith for the good of the other people and does not intend to cause harm even if there is a risk involved. With the permission of the court, I would also like to cite two cases. First one, the Supreme Court's decision in the case of Marshall versus Curry, 1933, illustrates the exception to the rule that an unauthorized procedure may be justified if the patient's medical condition proves no delay and warrants immediate action without waiting for the patient to regain consciousness. In this case, my client took the decision to preserve the patient's fertility to prevent further complications by doing the surgery. In the case of Kusum Sharma versus Batra Hospital, it was held by the Supreme Court that a doctor often adopts a procedure which involves a higher element. But in doing so, he honestly believes that it will provide greater chance of success for the patient. In my case, I would like to point out that there was no higher element of risk. It was a standard procedure. The tumor was only supposed to be removed. There was no higher element of risk except the standard complications that are associated with any other surgery. If the doctor has taken a higher risk to redeem the patient out of his or her suffering and it did not yield the desired result, this may not amount to medical negligence. And towards the end, I would also like to point out, in this case, my client took the decision in favor of beneficence of the patient. And I think in this case, beneficence goes over reproduction. And with here, I would like to pass this on to take up the next issue by my co-counsel, Kritika.
So continuing from here, I, Kritika, hereby would raise the second issue for today in front of the jury, that is, whether infertility is a form of disability and hence doctor's decision to resect the tumor without the consent to prevent disability is an exception to obtaining informed consent to safeguard protection of life under Article 21. As clearly mentioned, the tumor could have resulted in infertility of the patient. I would like to discuss the relevance of infertility as a form of disability in this case, how it would prove that be an exception to obtaining informed consent justifying my client's action. According to WHO, infertility is defined as a disease of the reproductive system and results in disability. Despite the high burden, couples and individuals who want but are unable to achieve and maintain a desired pregnancy have needs which are not being addressed, especially in the lower resource settings worldwide. A major landmark of adopting infertility as a disability by WHO was in 2019. In relevance to the above, I would also like to bring upon the fact that disability significantly reduces the quality of life of the individual. Hence, my client action ensured quality of life of the appellant. Right to life is a fundamental right provided by the Article 21 of Indian Constitution, which declares no person shall be deprived of his life or personal liberty except according to the procedure established by law. So the right of life in India is perceived not just as a mere animal existence, as stated by the fellow team, but also the right to live with human dignity, right to health, and right to a quality life, which was preserved by my client through his actions. Coming to informed consent and its exceptions, when the time required for disclosure would create a substantial risk of harm to the patient, obtaining informed consent may not be necessary before undertaking the required intervention. To be noted that such a practice must be followed only when there is an immediate and significant risk of a patient's life or potential for permanent disability to arise. Keeping the above statements by WHO and the Article 21 and regarding the informed consent, in our case, my client provided the appellant with the benefit of living a disability-free life by preventing infertility, which amounts to safeguarding their right to life under Article 21, and the surgical procedure could to prevent any disability is an exception in terms of requirement of consent. I would like to stress that again that the procedure performed ensured a quality of life for the patient by eliminating the risk of disability under Article 21. I would like to give the floor to Pankuri for the next issue. Thank you.
The most pressing issue today is not about the tumor resection, but whether the claim that the post-surgical complication resulting in amputation was actually due to the doctor's negligence. Post-surgical complication in this case was an infection which led to the gangrene of the left arm and eventual amputation. As we may agree, infection is a post-surgical complication mentioned in all standard textbooks that can happen even after a surgical examination. The patient had given an informed consent for the surgical exam, implying that she was informed of complications such as infection as a result of the surgical intervention. Had the tumor not been resected, the surgical examination could have also caused the infection due to the invasive nature of the procedure. Post-surgical infections, despite having the most sterile environment, have a way of occurring due to the multiple factors involved. Therefore, it is not right to hold the doctor liable for its occurrence as it is highly unpredictable in nature. In Vinod Jain versus Santokba Dharlupji Memorial Hospital case, the Supreme Court mentioned factors that have to be considered while establishing the liability in medical negligence cases. So the Supreme Court says that a doctor cannot be said to be negligent if his acts are in accordance with the set guidelines merely because somebody holds a contrary view. The doctor need not have special expertise but must display ordinary skills of that profession to be not liable for negligence. And the last and the most important, a doctor cannot give assurance for any recovery as it is not in their hands and they can only try their best. The only assurance they can give is that they hold requisite skills in their profession and they're performing their degrees to the best standard of care that they can. Similarly, this particular judgment was also used to rule in state of Haryana versus Srimati Santra case by the Supreme Court that it is the duty of every doctor to act with a reasonable degree of care. However, no human is perfect and even specialists can make mistakes, but they will not amount to negligence in case we can prove that the reasonable care is being acted upon by the doctor. Similarly, in Achutrao Haribhav Khodwa versus State of Maharashtra case, Supreme Court noticed that there are multiple admissible courses for the same disease and same condition. Therefore, we cannot hold a doctor liable as long as he's performing the duty with due care and caution, mainly because they choose a course that is a little more risky or different than what somebody else thinks. As noble as this profession is, it is not perfect. And there are multiple variables that are out of control of the doctor and can be the cause of such mishap as what we've been talking about. To serve humanity through medicine, our clients, Meera Devi Hospital, have worked relentlessly to ensure that they act only and only in the best interest of the appellant, Mrs. Ramita Bindra. We would like to conclude by stating that the respondent's decision to go ahead with the surgery is justified under the bioethical principles of beneficence and non-maleficence, guided by the Hippocratic Oath, hence must not be wrongly termed as negligence. The infertility amounts to disability, as WHO stated, which reduces the quality of life. By going through the surgery, the respondent mitigated the risk of permanent disability, thereby safeguarding the appellant's right to life under Article 21. Hence, this is an exception to the requirement of informed consent in the Indian Code of Ethics and cannot be termed negligence. The post-surgical complications resulting in amputation cannot be assumed to have been caused by the respondent's direct negligence and they cannot be held liable for unpredictable complications such as these. Therefore, in the light of all the issues that we have raised, we would like to humbly request the Honorable Court to uphold the orders passed by the District Court of acquitting the doctors of any charges of medical negligence as lawful and to relieve the hospital of any charges of medical negligence henceforth in this case. We would also request the Honorable Court to show faith in the institution of medicine and also restore the trust of the general population in healthcare workers. All of this is humbly prayed by the counsel for the defendants. Thank you.
So that was a real presentation. MSAI
All right. Well done, teams SIMSA and MSAI. We'd like to yield this to the jury. Dr. Shiv, Do we have the floor open for rebuttals?
Yes, I think it calls for a rebuttal.
Dr. Shiv, do we have the floor open for rebuttals?
Yes, Prachi, can you hear me? I think, yeah, we need a rebuttal.
Okay.
You can
Sir,
open the
can
call.
we do 5
Yeah.
minutes?
Yeah, sure. 5 minutes is good.
Okay. Yes, sir, we can hear you. Yes, sir. Okay, so the floor is open for rebuttals and the total speaking time will be 5 minutes. Every rebuttal will only be allowed for 30 seconds. So the time starts
I'm so
now.
sorry. I just wanted to ask the question for 30 seconds, right?
Hamza, can we display the clock?
Is it visible?
Excuse
And
me.
I'm using a stopwatch for the same.
We had a small doubt. 30 seconds is for asking the question, right?
Yes. Rachna?
And if the reply to the question, it also has to be within 30 seconds, or what for that?
I'm not sure if Prachi is able to hear us.
I guess she's facing some network issues. So the 30 seconds is for asking the questions, and for reply also you get 30 seconds only, since we are also running a bit short on time. So I hope that's fine with Woods.
I had a doubt. We have 5 minutes for rebuttal, so that means that includes all the questions and all the answers that can be done within 5 minutes.
Yes. So like
Okay.
it's 9 now, so we'll go on till 7:14 or 7:15 max for the rebuttal.
Okay.
Sure.
And there's a strict 30-second timer for answering, or is
Yes.
there any leniency?
There's a strict 30-second, I guess. Dr. Shiv, it's on your decision. Do you want to increase the time, or is 30
Yes,
seconds fine?
yes, no, we'll keep it as 30 seconds for the question and 30 seconds for the answer, and we shall not exceed 5 minutes.
Okay, sir. Thank you, sir. Okay, so the first question, can I have hands raised, please? Okay, so Samukta has raised a hand, and we'll follow that by Snigdha. Okay.
Yeah.
So your time starts now.
The respondent had made 1 or 2 points that I would like to address. The respondent had stated that the quality of life was preserved by doing the surgery. I don't understand how exactly the quality of life was preserved by the surgery, because as the surgery was done, that led to amputation of her fingers, that led to loss of livelihood. And the only important point for removal of the tumor was said to be fertility. Fertility is not an emergency condition. It can be.
Time's up. Sorry to interrupt. Your time's up. Okay. So Team MSAI, hold reply from your side. It's Pankuri.
Yes.
Okay. Yes.
Yes. So the question being,
Just a minute. It's Ria, right?
yes, it's Ria.
Okay, so your time starts in 3, 2, 1. Your time's up.
Yes, we stated that the surgery was done in order to prevent disability. First of all, because we defined that according to WHO, infertility is termed disability, and the exception to informed consent is that the emergency condition includes a life-threatening condition as well as a potential risk for disability. On grounds of that is our client made the decision to go ahead with the surgery. Yes.
Okay, thank you very much. So the second, we have Snigdha.
Thank you, Hamza. Am I audible?
Yes, you're audible. Your time starts in 3, 2, 1. Yes, you can go now.
With due permission of the court, I would like to raise one rebuttal. The respondent stated that a second surgery was avoided, and we in the petitioner side completely agree. However, the onus lies on the respondent to prove to us why the surgery was undertaken in the first place at all, when the patient adamantly refused anything but the examination of the fibroid, and that is it.
Okay. So who would like to reply from Team MSAI?
I'll be going ahead.
Okay, so Pankriya, time starts in 3, 2, 1. The time's up.
I request the counsel for the appellants to please go and check the statement of facts and the case, which clearly states that a surgical examination was consented to by the patient. So the surgical examination of the fibroid was consented to by the patient, which is why the first surgery went ahead. And as was very beautifully explained by my co-counsel, we then went ahead with the second part of the surgery because of prevention of disability.
Okay. So moving on, the next question we have is from Pankadi. Just a minute, Pankadi. I'll start the timer in 3, 2, 1, and time is on.
We want to ask the appellants what essentially were the cases they cited during the issue raised for compensation, because those cases were talking about radical procedures like hysterectomy and other places wherein risks were massive. But in our case, we only benefited our patient by removing the fibroid and there were no other risks. So how can we take those cases as a margin and judge our case? Are we trying to deflect from the point over here? Or
time's up,
yeah.
Pankadi. Okay,
I
so
would
who would
like to
like to
answer this. Snigdha, I would
Okay,
like to
Snigdha.
answer this question from the petitioner side. That the two cases that we stated and the case on hand are very similar in context of medical negligence, which is the root of what we are debating here. Because we cannot isolate an incident as a drastic procedure, and we cannot ignore something as basic as consent as something very insignificant, because consent is a very big and strong pillar of medical practice in India and the world abroad. So yeah, so
Okay,
that
I'm
would be
sorry
my
to interrupt.
reply to that.
Okay. Okay, sure. Thank you. So moving on, who has raised his hand?
Excuse me, can we please request the jury for permission to cross-question the same person?
Dr. Shiv, do you give the permission?
Yeah, we can allow one cross-examination.
Okay, so one cross-examination. So Pankadi, you'll be going ahead?
Yeah.
Okay, so your time starts now.
As per what the counsel for appellants said, we are again stating that time and again Supreme Court has said that negligence is of varying degrees. There is criminal negligence, civil negligence, and then there is professional misconduct. So a hysterectomy and removal of a fibroid tumor which saved a patient will not fall in the same parameter at any cost, and this is what we've been trying to portray.
I would like to answer and actually thank. I would actually try to thank the respondent.
Excuse
for.
me, sorry, Snigdha, just a minute. It's 7:15.
Yeah.
Dr. Shiv, would you allow Snigdha to speak, or shall we end this cross-question?
No, we'll just take this answer and we'll end.
Okay.
Yeah. Okay.
Thank you.
Thank you to the jury. Thank you to the jury, and also thank you to the opposition for actually making the distinction, because we are exactly trying to prove exactly that. Because if consent is not taken into consideration, if consent is so insignificant, we can also raise the argument that infertility can also not be qualified as an emergency and cannot be acted upon without the consent of the patient. So while the two cases might have different punishments, they are still liable for judgment in the court. Thank you.
I'm sorry, thank you.
Yeah.
Okay.
Thank you.
No issues. So, Dr. Shiv, is that fine?
Yes. We can move ahead.
Okay, sir. And could you like to speak something about both the teams and about the performances?
Yeah, sure, Hamza. Thank you. I think it's a very a complicated case when it comes to an ethics point of view, because on the one hand, we are looking at autonomy being compromised. On the other hand, we are also looking at equal and very strong cause for beneficence. So these are always the conflicting pillars whenever we talk about ethics. So I think we've had some very wonderful views here, considering the way you've applied your knowledge of bioethics as well as law to answer these queries. Also, I was very impressed by the advocacy skills that you've demonstrated. And it becomes very important to defend whatever you're saying. I mean, there might not be a right or wrong in this. So the way you're defending your rounds, it seems pretty impressive. I think let's move on to the next teams. I'm now even more excited to see how the next teams perform. Thank you.
Sure. Thank you very much, Team MSAI and Team Simsa. We'll get back to the results together at the end of the case too. Okay, so moving on, Team AMSA and Team RCC. Yes.
I think we can show the second case.
Okay, sure.
Team AMSA and Team Rotaract Club of Caduceus. Are you ready?
Yeah.
Okay.
Yes.
Okay. Here's the case. Cedric Gonzalez suffered from arteriosclerosis and was advised to undergo diagnostic aortography at Meera Devi Hospital. He was put under anesthesia. His aorta was injected with X-ray contrast medium, and X-rays were taken of the blocked abdominal aorta. The next morning, Gonzalez discovered that his lower limbs were paralyzed. Such adverse events were not explained to Gonzalez as they were a very rare occurrence, but the district court acquitted the doctors of any charges of medical negligence as this was a chance occurrence. Gonzalez files a petition in a higher court against this judgment and demands damages. So let's look at the statement of facts. Next slide.
I am on the next slide.
Hamza, can we change the slide?
Actually, I'm on the next slide.
Okay. Cedric is a 55-year-old man with history of Okay. Got it. He underwent a harmless stabilized his lower limbs the next day. Meera Devi Hospital is a part charitable, part private hospital run by a trust, and it employs doctors and other staff to provide free treatment during specific hours and private consultations during the rest of the day. So here are the statement of facts. We have Team AMSA versus Team RC Caduceus. The first, that is the appellant, that is the Rotaract Club of the Caduceus, goes first. Team Rotaract Club of Caduceus, are you ready with your teammates?
Yes.
Okay. Please make sure that all your cameras are on, all the team members. Okay, your time starts now.
We, as the counsel for Mr. Cedric Gonzalez's case of medical negligence, would be representing the appellant in this case, the facts of which are as follows. Before that, I'd like to give a little background information. Mr. Cedric Gonzalez is a man in his mid-50s and most probably, considering his pre-existing arteriosclerosis, had almost a good decade of quality life left. If he continued with the medical management of his disease and impeding his ability to live a healthy life and provide for himself and his family by earning a livelihood. The accused actions led to physical, physiological, and financial harm to the appellant. They will now have to undergo physical rehabilitation, invest in expensive orthoses like specialized wheelchairs, and most importantly, they will now be dependent on other people to enable them to perform basic chores of his life. These may also lead to psychological damage to my patient, as they're suffering the consequences of something they did not know that would occur to them and prepare themselves mentally. They may alienate themselves from their family and friends due to their condition and may necessitate therapy in the future. This has abruptly led to a decrease in the quality of his life. I would like to raise the following issues. Firstly, the patient was not notified of all potential risks associated with the procedure. Secondly, Physicians simply cannot understate the known dangers of a procedure in order to obtain a patient's consent. Third, the very first principle of bioethics, that is autonomy, was breached. Fourth, the entire event would have been avoided had a better doctor-patient relationship been established. And fifth, there was no care taken for reporting the ADR to the central authorities for further avoidance for recurrence of a similar incident. I would like to summarize these as we plead our case in this honorable court and jury today, since in 1995, the Honorable Supreme Court of India, in the case of Indian Medical Association versus BP Shanta and others, held that if in any service was provided with a medical professional or a hospital in exchange for consideration, then said service would be covered under the purview of the Consumer Protection Act 1986, thereby allowing the patient to seek redress as a consumer in case of any dispute. Therefore, we discuss our issues under: the patient was not notified of all potential risks associated with the procedure. The principle of informed consent was breached, as the patient was only partially informed about the procedure and its risks. Transparency by the treating physician about the possible risks of undergoing any medical procedure empowers the patient to make an independent decision. Physicians simply cannot understate the known dangers of a procedure in order to obtain a patient's consent. A physician violates his duty to his patient and subjects himself to liability if he withholds any facts which are necessary to form the basis of informed consent by the patient to the proposed treatment. According to the Universal Declaration of Bioethics and Human Rights by UNESCO, any preventive, diagnostic, and therapeutic medical intervention is only to be carried out with the prior, free, and informed consent of the person concerned based on adequate information. The consent should, where appropriate, be expressed and may be withdrawn by the person concerned at any time and for any reason without disadvantage or prejudice. Third, the principle of autonomy was breached. According to Article 5 of the Universal Declaration of Human Rights and Bioethics by UNESCO, the patient has a right to autonomy which has been breached. And also according to Article 21 of the Indian Constitution, the autonomy principle has been breached. Autonomy is often misinterpreted as do exactly what the patient wants. However, in reality, that is not the case. Only adequately informed patients can rightly exercise their autonomy, which was entirely which did not happen in this case. Every human being of adult years and sound mind has a right to determine what shall be done with his own body. Had the patient been incompetent or there was some problem associated with him, then not informing the patient about the condition would have been justified. However, that was not the case. Therefore, the doctor is wrong in this decision of not informing the patient about the risks associated with the procedure. Autonomy and informed consent go hand in hand. One simply does not exist without the other. Unless and until you properly inform the patient about the procedure he or she is about to undergo, there is no way that autonomy can be fulfilled.
With due respect and allowance of the respected court, I would like to cite a few cases which were previously held under the same topic. And for the first case, I would like to cite the example of Balchandra alias Bapu and others versus the state of Maharashtra of 11th of April 1968, where I would quote the statements of Honorable Supreme Court of India that criminal negligence is the gross and culpable neglect or failure to exercise reasonable and proper care and precaution to guard against injury either to the public generally or to an individual in particular, which having regard to all the circumstances out of which the charge has arisen, it was the imperative duty of the accused person to have adopted. Also, I would like to cite another case of Pindamaneni Narasimha Rao versus Gundavarapu Jayaprakash, in which a clear case of negligence was established and the state has clearly found negligent due to the activities occurring in the government hospital, which discreetly indicates a precedent for holding institutions liable, irrespective of them being government or private institutions. Thus, it is the council's belief that Devi Hospital is also liable in the case of my concerned client. I would cite another case from 2013 of Balaram Prasad versus Kunal Shah and others. It is a landmark case in all judgments made for negligence so far, as we would also petition the case for lost wages as a defendant was rendered incapable of earning his livelihood following the procedure, as well as for the loss of income of his dependent family, as Mr. Gonzalez was the primary earning member of the family. Based on the above mentioned precedents, we believe that a clear case of criminal negligence for which both the hospital and the doctor should clearly be held liable and clear compensation must be given.
Your Excellencies, now I would like to move on to the two issues left. And one of those is this entire event would have been avoided had a better doctor-patient relationship been established. Now, for a good doctor-patient relationship, doctors should consider the patients as their clients and handle them with confidence, humility, concern, and empathy. Now, even if the patient would have been anxious after getting to know about the dangers of the procedure, it would have been better if the doctor would have calmed them. This would have been possible only if a good doctor-patient relationship was established. The physician has to be vigilant in pursuing the spirit of informed and intelligent consent by the patient. The last point issue raised was there was no care taken for reporting the ADR to the CDSCO for further avoidance for recurrence of a similar incident. We were not provided with discrete information about what further procedures were taken to avoid certain ADRs in the future. The hospital did not take initiative to perform the pharmacovigilance by voluntarily reporting this incident to CDSCO in an effort to make regulatory authorities aware about it. There is also to consider the possible use of off-label or expired contrast medium. The off-label use of a medical product is its prescription and use in a manner and for purposes other than that approved by authoritative agencies and national drug laws. So there was no institutional committee set up to investigate the incident in all of these views to rule out any manual, technical, or pharmaceutical error. Based on all the facts presented to the Honorable Court in favor of a client, we conclude that in this case, there was medical negligence occurred on account of the treating doctors, and there was breach of informed and intelligent consent, a very crucial aspect of bioethics. Moving on to our prayers, therefore, in the light of the issues raised and the arguments advanced, it is humbly prayed that the Honorable Court, 1, to declare the orders passed by the District Court against doctor as contrary, 2, to charge the doctor with charges of negligence, breach of informed consent, and attempt to hide information, 3, to charge the defendant for the failure in adopting proper measures in reporting the ADR and to be guilty of being unable to avoid the mishap by allowing the appellant to take informed decision in the best of their knowledge, and pass any other order, direction, or relief that this Honorable Court may deem fit in the interest of justice, equity, and good conscience, all of which is humbly prayed counsels for the appellant. Hereby we give closure to the
Thank you very much, Team RCC. Yes, Keegan.
We have the remaining 5 minutes for rebuttals. I was waiting for that. If
No.
We're doing it.
No, we'll have the rebuttals at the end of the session.
I think we can go ahead with Team AMSA to present.
Am I audible?
I guess no.
Am I audible? Can you hear me?
Yes, that is a bit better.
Should I start?
Yes, you can start in 3.
Actually, Prachi ma'am's voice is breaking, so I'm not sure if it's a problem on my end or on her end.
Tushar, I can hear you very clearly.
Yes, Tushar, you can start in 3, 2, One, and the time is on.
Greetings to the honorable judge and the eminent jury. We are present here today in the capacity of counsel for Meera Devi Hospital, which has become a victim of a vicious and malaligned lawsuit, which lacks the basic legal grounds and scientific evidence to support the claim of damages. It becomes imperative for public law and order, tranquility, that such claims be finely scrutinized and, when deemed false, struck down to protect the institutes of health and healing, such as our client. Beginning with why the filed petition should be declared void is, I'll raise the first issue. There are insubstantial legal grounds to pursue and prove medical negligence. The Section 80 of the IPC says that nothing is an offense which is done by accident and misfortune and without any criminal intention or knowledge in the doing of a lawful act in a lawful manner, by lawful means, and with proper care and caution. When a patient agrees to go for medical treatment or a surgical operation, every careless act cannot be termed as criminal or as a liability. It can be termed as criminal or as a liability when there is a gross lack of competence, ignorance, or negligence. Legally, our client was well within his rights and his mandate and responsibilities. He was following the standard protocol that has been laid down and was operating under the umbrella of informed consent. Moreover, I would like to cite a case of Dr. Suresh Gupta versus the government of NCT of Delhi and ANR, in which the judgment that was released said, quote, the act complained against the doctor must show negligence or rashness of such a high degree as to indicate a mental state which can be described as totally apathetic towards the patient. As we have seen from the statement of facts, this is quite contrary to what we have seen in the case. Moreover, prosecutions of doctors without adequate medical opinion pointing towards their guilt would be doing a great disservice to community. You ask me why? Because at large, if courts were to impose liability on hospitals and medical professionals for everything that goes wrong, the doctors would be more worried about their own safety than giving the best treatment that possible to their patients. This is also very significant in our case, since our client provides a part-time charitable service, and trust is the basic driving force which brings people for healing them. Moreover, as the opposition team mentioned, I would also like to quote the case of VP Shanta, the same case that they cited, in which deficiency is a fault, imperfectness, a shortcoming, or an inadequacy. Following this, the judgment says that performance of a medical service rendered cannot be judged on the basis of any fixed norms, and therefore, in medical practice, it cannot be termed as a service. So, if it cannot be termed as a service, then the basic right, section 2, clause 1 of the COPRA, the Consumer Protection Act, cannot be invoked, and damages cannot be demanded if medical service cannot be rendered or be called as a service. Finally, such petitions undermine the basic trust that binds together the diseased with the healer, questions the intentions of doctors who work day and night to keep disease at bay. Hence, I request His Honor and the eminent jury to uphold the foundation of healthcare and also analyze the thin ground of logic on which the petition resides, unsupported by substantial evidence. With this, I yield to Keegan.
Thank you, Counsel. Thank you, Tushar, for that wonderful introduction. Good evening to the jury and respected judge that we have here. Before we get into the legalities of this case, the actual thorough legalities, I just want to deviate a little into the community medicine and bioethics aspects of this case. When you're talking about community medicine, there are a few concepts that we need, I think even the appellant needs a revision in. Number one being the concept of correlation and causation. Correlation, for those who aren't familiar with the concept, is when something is interlinked loosely to something else. Suppose, for example, say my computer dying because I'm not being able to play games because my computer has died. That is, both of them are caused by the fact that my battery in the computer is over and not by each other. So they are correlated to each other, but they're not the cause of each other. However, causation is when there's a direct cause that is that exists in proving that a point is caused by a certain other thing. When it comes to this case, there is no correlation there is no causation that has been proved when it comes to actually the arteriography causing the paralytic attack, number one. Apart from this, there is a very, very important confounding factor that we need to consider when we're talking about the paralysis that has happened. The patient has been, like the appellant side said too, a long-standing case of both cardiovascular disease and atherosclerosis. Now, all of these, I do not think anybody needs a revision, but all of these also happen to be risk factors for strokes, and strokes obviously do cause paraplegia, which the patient is currently facing. So that said, I don't think, with the possibility of a confounding factor already in this whole scenario, apart from the fact there is no substantial evidence to prove that the arteriography actually causes stroke, should we ever pass a judgment whether there was medical negligence or not? Say that, okay, there was a causation factor between the stroke and the arteriography, still all pre-procedural norms were followed. A general examination was done of the patient, consent was taken of the patient, and even though the appellant does not feel like me at this point, informed consent, all of the procedures, the way of doing the procedure, the threats that came with the procedure, the pre-procedural and post-procedural protocol, all of that was explained to the patient. Allergic history was taken of the patient, allergic test dose was done of the patient, all past medical history was considered before doing the diagnostic procedure that was done. So that brings me to my next point. According to Lord Wright, and I think every second-year medical student knows this, that according to Lord Wright, for medical negligence to be proved, there needs to be an association of 4 Ds. The first D being duty. Was it the doctor not doing their duty? I do not think so. Number 2 being derelict. Was there any dereliction? Was there any deviation from normal duty? I again do not think so, and I see none. Was there any damage caused? There was damage caused, but was that damage directly associated with the doctor's actions? Again, there is no actual substantial proof for that. And a direct cause, the last C happens to be direct cause, which cannot be determined. Apart from that, coming to the point of informed consent, every time we're taking informed consent of a patient, we try, medical professionals try their best to explain all of the adverse events that can happen in a case. However, unlike what the prosecution was saying, we cannot explain unknown adverse effects. I believe the verbatim was using known adverse effects, telling them you cannot tell them only the known adverse effects. Obviously, for purposes that I don't need to explain, we cannot tell them the unknown adverse effects because nobody knows what those unknown adverse effects are. But all known adverse effects were explained to the patient, and all frequently known adverse effects were explained to the patient. That is how a lot of medical professionals function in their normal day-to-day practice. Apart from that, informed consent is still legal if the doctor does invoke therapeutic privilege, which can be said to be invoked in this case. The last point that I would like to bring forth is the point of beneficence and non-maleficence when you're talking about it from a bioethical point of view. Was this procedure done for the benefit of the patient? My counsel, and I'm sure the appellant's counsel also does agree with me when I say that it was done for the benefit of the patient. Was there any malicious intent when we were doing this procedure by the doctors? I believe there was none, and there is no evidence to prove that there was any ever malicious intent that was taking place. So with that, I'd like to yield to Dr. Avi. Thank you for your time.
Hi, thank you, Keegan, so much for that. Greetings, Honorable Judge and all present. As stated before me by my co-members of the council, I shall extend another argument why the petition as filed by Cedric Gonzalez demanding damages against the court's order does not really hold substance. I would like to direct the attention of the honorable jury towards the fact that omission of medical opinion remains subject of personal interpretation, thus excluding the possibility of any negligence in this case. I just don't say that. I will just help you exemplify that by examples that I have in hold and making analogies. The guidelines laid down in Kusum Bharti and others versus Batra Hospital for grounds of negligence, the 5th guideline clearly says, in the realm of diagnosis, treatment, there is scope for genuine differences. I underline the word genuine over here. There is a scope of genuine differences of opinion, and one professional doctor is not negligent merely because his conclusion differs that of another doctor. Hence, taking into account the patient history and circumstances, the doctor's omission of the fact is well within his legal purview. I just don't say this on behalf of the person who's appealing. I even refer to here when the difference of opinion lies with another expert like a doctor. Even then, it is in realm. In this case, I don't think that Mr. Gonzalez is an expert of medicine itself. However, I would like to exemplify my claim with two issues that might be raised here. So, helping the other understandable and within the legal rights of our client. Firstly, the validity of consent is what is being questioned. The second thing, I hope I'm still audible and visible. One second.
Right. Yes, your voice just broke for a moment, but then it was audible.
All right, thank you. So the first is a valid consent. A valid consent consists at the minimum with respect to a few elements, like the condition that the person is suffering from, the procedure, and the treatment that is intended, the consequences of that treatment and also its alternatives, and very importantly, the consequences of not getting that treatment. Along with it also consists at the minimum the common complications, and that I would very confidently say were all met in meeting a valid consent criteria. Not every possible complication needs to be explained, because there is always a possibility, although however negligible, nothing can be reduced down to zero. Even if we believe, and I say even if we believe, that the event might have somehow been related to the procedure, the stats support the possibility that it was unpredictable to be a complication as much. Secondly, when you consider a case of negligence, we go by something called the model of reasonable care, which compares the act under consideration to the management given by contemporary doctors in the area they would offer as per reasonable standards, not necessarily the most ideal. Why is that, you ask? Because what is ideal will vary as per the subjectiveness of the doctor. Again, I agree that not everyone is very well versed medically. So I will want to exemplify by giving an absolutely beautiful analogy over there. What might be considered a possible diagnostic treatment for a symptom might be deemed absolutely unnecessary by others. For example, an MRI is actually not recommended for back pain because the commonest cause is lumbosacral strain, because it is actually rather considered wasteful and even unethical if I ask someone to get an MRI without any indication for back pain. Similarly, in this patient, the patient who was going aortography as per reasonable standards, it was monitored for immediate complications, for example, an anaphylactic shock after the contrast, because that is a predictable complication, by keeping the patient under supervision for a few hours. Now you ask, why would we not extend the supervision beyond that to have predicted something that might have happened days after or a delayed complication? Rather, keeping a patient beyond that might have been unnecessarily, and not even just that, it might even be distressing for a patient who might not need that inpatient care. With that, I shall move to the concluding remarks. In the light of the aforementioned issues raised and arguments, it is humbly prayed that the High Court firstly upholds the District Court's ruling of acquittal of all charges. Secondly, declares the petition void, being contrary to law. And besides that, I would also request the court to provide any order, direction, or relief that this imminent court finds in the interest of justice and equity. I rest my case. Thank you.
Thank you very much, Team AMSA. It was indeed really delightful to hear both the presentations, and both the teams presented the points really well. Okay, so moving on to the cross-question round. So how much time shall we give 5 minutes as well, Dr. Shir?
Yes, Hamza, we'll go for 5 minutes. 30 seconds of question and 30 seconds of answers. Yeah.
Okay, so could all those who want questions raise their hands? Okay, so we have. Okay, so I guess the first hand that was raised by Keegan. So Keegan, if you could go ahead, and your time starts. Hey Keegan, are you there?
I'm waiting for you to
so
say
your
time.
Okay, yes, so it starts now.
Okay, so to begin my question, firstly, I would just like to correct the prosecution when they say that an incompetent patient doesn't need to give. That was a verbatim that ma'am used. An incompetent patient needs to take consent from the next of kin according to Section 89 of the IPC. Secondly, there was most of the facts that you have presented was speculation, such as there was off-label use of drugs and there was no care taken for ADR and pharmacovigilance. My question being, how was autonomy breached? There is no, that it's missing from my case file. So could you all please explain how
And
autonomy
I'm
was
sorry,
breached?
time's up. Okay, so who would like to reply from the team RCC? Is anyone from team RCC there? Would like to reply to the question? Would like to reply to the rebuttal? Could you please unmute yourself and say your name?
I would like to.
Okay, so Sneha, so your time starts now.
We would like to remind the defendants that this complication was a known case and known and rare complication and not unknown. So as stated by the defendants as well. So in this matter, informed and intelligent consent was actually missing, wherein the patient wasn't informed about the ADR which could happen. And in this case, the patient definitely didn't know, and thus this case has been presented in front of the court.
And your time's up. Okay. So, yes. Okay, so moving on to the next rebuttal, we have Anudrita. Anudrita, okay, so your time starts now.
So as the opposition party mentioned that they compared humanly mechanism with computer and its schemes, I find it really wrong, because we cannot actually compare how human body reacts to something with a computer and its scheme, and it's completely correlated in this case, because this occurred only because of the use of something which already the doctor knew, even though it is a rare complication, but it happened.
And time's up, sorry. Okay, so would like to reply from Team AMSA. Could you please unmute yourself and say yes?
Okay, I can go ahead if everyone's there. Yeah. So
sure,
I would really
just
want to answer that question by.
Yes, I
would really want to.
Like this. Yes, you can begin now.
I would really want to answer that question by getting some facts in the picture. I hope everyone's done their research over here. Out of 100,000, 10,000 cases, about 6 people are known to have reported this complication, which also holds no substantial proof that it is a causative complication as much, more like a correlation. So I think when we talk about something that they need to be more common complications to consent, so we need to ensure not every complication is going.
Time's up. Sorry to interrupt. Okay, so moving on to the next. I guess it's Avi only. So you can start your rebuttal now.
Okay, as very well understood by everyone, the person who appeals and files a case of negligence, the burden of proving the negligence lies on the same party. So what proof would you want to keep that the complication was caused due to aortography itself? I would really want to believe that it's not just vacant and empty coincidental reasons. You have a substantial proof for saying that the aortography led to that complication, because the patient was fined between that time.
Time's up. Sorry to interrupt again. So who would like to answer from Team RCC?
I would like to answer for this. As mentioned,
Your time, start after I say your time, sir. So your time starts now.
As already mentioned, and it's already stated in the case that it's a very general procedure, so there is no chance of mistake. There's a very less chance of mistake in that particular procedure to be followed. So the alien thing which was introduced here was the X-ray medium, and since it already has, even though a rare chance of side effect, and it has occurred, and the side effect has to be this. So since it has occurred, so we definitely consider this is the only reason.
And your time. Sorry to interrupt. Your time's up. Okay, so we'll be taking just one last question because 5 minutes are about to be over. So Sumaya, since yours is the only hand, you can speak, and your time starts now.
We would like to remind the defendants that the complication which occurred was a known and rare complication, and not unknown. If it was unknown, then their not telling the patient about it would have been justified. However, it was a known complication, and although it was rare, it was known. Kindly explain how omitting information is allowed for informed consent.
Can I take that question?
Yes, your time starts now.
This is me citing S.K. Singhal, Forensic Medicine and Jurisprudence, the 5th edition, page number 50, where it says that informed consent has exception to it, and therapeutic privilege is very much one of those exceptions. Therapeutic privilege means that the doctor can, if it does interfere in the diagnosis or the treatment of said case, a doctor can withhold information and it's still considered to be informed consent. So that is very much practiced in India, and although it is not in the UK and the US, it's very much practiced in India, and that's why we can vote.
Sorry to interrupt, but time's up. Okay, thank you very much. Dr. Shiv, would you like to say something?
Sure, thank you, Hamza. Again, very wonderful presentations from both the sides. Of course, when such cases arises, we need to understand the standard of care that is in existence and the protocols in place, and whether if we look at the case more minutely, or if we look more closely, we need to understand whether the entire protocol for the procedure was performed correctly or not. Second, considering the idea of informed consent, I think we all must understand one thing. Covering covering with more information and informed consent may not always be better. So there has to be a system to it. There's a concept of nocebo. Okay, so just like a placebo, we also have a concept of nocebo. So they say about these are just studies. We do not know it for sure, but we have some evidence suggesting giving more than required information in certain aspects of therapy have led to more harm to the patients than benefit. So we need to further deliberate such cases, and I think that is where we start learning the real boundaries of our our decision making processes when it comes to ethical dilemmas. Thank you, Hamza.
Okay, thank you very much, sir, for your inputs. Dear delegates, we really hope that you enjoyed this session. Both the cases were very interesting, and all the teams presented good arguments. And I hope the YouTube audience that has also joined really enjoyed listening to the arguments as well and the questioning. So to compile scores and announce the judgments of both the semifinals, we require a bit of time because to be sure and we want to be perfect. So we'll be meeting again, and also since all of you are really tired, we'll be giving you a break of around 20 minutes. And I guess it's 7:56 now. So we would meet at 8:15 if that's fine with everyone, and we'll announce the results then for the semifinals. Is that fine with everyone? With all the teams as well as Fatima?
Yeah, it's fine. I think the teams can put in a plus in the chat box.
We can meet again at 8:15 if that's fine with everyone.
Yes, sir.
Yes, 8:15.
Okay, then we'll reconvene back in 20 minutes.
Thank you everyone for joining. Hello, delegates and everyone. Welcome back. I would also request any of your teammates, if they have not, you could request them to join in, please. Because we'll be announcing the results real soon because we have a finale round to conduct and we require time for that as well. And we do not want to exceed the time.
Can all the teams please put in a plus in the chat box if all your team members are here so we can announce the results now? Okay, team Amza and Simza. Okay, I think everybody is here.
So, hello, Prashna, am I audible?
Yeah, you're audible.
So, I guess let's announce the results now. You all might have been waiting for.
Dr. Shiv, we are good to go with the results, correct?
Yes, Prachi. Yes.
Okay, so we had a very good debate, and in the first case we had MSAI versus Simza, and in the second one we had AMZA versus RC Caduceus. So here are the results for the first case. We have yes, so the first in the first case team MSAI has made it to the final round with the score being 164 out of 200, and the Simza has got 160 out of 200. We'd like to reiterate that we have rated you on the basis of, so congratulations team MSAI. We have to agree that the scores were very close and it was a very, very close call. So congratulations team MSAI. This was for case 1. Let's move on to the case 2. So in the case 2, we had AMDA versus of Caduceus. Again, it was a very close call. So the winner for this round is Team AMZA. So Team AMZA has scored 160 out of 200 and Team RC Caduceus has scored 155 out of 200. Again, it was a very close call and that is the decision from the jury. And respectively from case 1, Team MSAI, and from case 2, Team AMZA have made it to the final round. Dr. Shiv, would you like to say a few words?
Yeah, thank you, Prachi. All right. So I think in such competitions, it becomes very difficult to judge because, when I was listening to all the teams, it becomes very difficult to rate you all because see what happens is one of the team will be too good in presentation style, advocacy. One team might be better in knowledge and application of bioethics and law. So, you might actually score a bit higher in one domain and a bit lower than the other team in the second domain. But the aggregate comes out to be very, very close. It comes out to be very close because the overall quality of your presentations is very good. It's very impressive. And the amount of work you put in, because I in no manner I can say that any of the team deserves less or anything like that, because it's not possible to judge such an event with I think with a very taking into account like those very, very little things. And I tried to score in this. I attempted to give my best while I was judging this. So I think this was one of the most difficult events that I have judged so far. And I think congratulations to all of you guys for putting in such wonderful show and efforts today. I'm really excited to see how the final round goes. And because I am pretty sure that's going to be tougher than this. So yeah, go ahead.
Thank you so much, sir. With that, I think we can go on to our final round. Considering that for the final round, we have a completely different case, and congratulations to the winners. And the Rotaract Club of Caduceus and Simza are free to watch because this is again going to be very interesting. Considering that we have not had any prep time for this case, and we will just be giving you 10 minutes, and this is going to be more of an individual effort on every participant's end. So we'd like to go on with the case here. Hamza, can we have the final case on the screen?
Is the presentation visible?
Yes, it is.
Okay, so shall I proceed on directly to the case?
Yeah, you can go on. So for the rules and regulations, they will remain the same as they were in the previous round. Since this is not going to be any, there's not going to be no written submissions. So we're just going to debate based on the very same clauses that we had judged you in the previous round. So here is your case. Madhuri Sharma, who is age 18, she's mentally retarded and institutionalized. She was the daughter of a mentally retarded woman, that is Lata Sharma, who lived in the same institution and was herself the daughter of an illegitimate mentally retarded child. So this was 3 generations of mental retardation. The state-run institution conducted sexual sterilization of Sharma by salpingectomy, the cutting of fallopian tubes where fertilization takes place, an operation that would not affect her general health. This was conducted by the gynecologist Dr. Mishra at his nursing home. An NGO known as Mahila Samiti sought to move against this act, arguing over Article 14 of the Indian Constitution. So, moving on to the statement of facts. Okay, so in this case, I think we'll leave the case for a while on the screen right after we have allotted the roles. Here are the 6 roles that we will be allotting to the 6 participants, that is who are in the final round. Team AMSA including Avi, Keegan and Tushar, and in team MSAI, Pankhuri, Ria and Kritika. So can we have the name allotment now? It will be done on a random basis, and we will be doing that now.
Okay, sure.
I'd just like to go on with the basically the rules of this event while we are sorting out the names. You will be allotted, you in your personal capacity are a lawyer who would be fighting for these clients, that is the NGO, the government, the Dr. Mishra, Madhuri Sharma and her mother Lata Sharma, and all of these people. You will be arguing on behalf of these people as to why your client in that particular scenario has to you're arguing why they should, the court should uphold their rights and dignity in this particular scenario, and why they are correct in this particular case, whatever it has to be given. So the ruling will be given, the court ruling might or may not be given in at the end, but you would have to, as a lawyer, argue on the behalf of these particular people. So we have, just to go again, we have the NGO, we have the government of India, we have Dr. Mishra, we have Preetam Sharma, Madhuri Sharma and Lata Sharma. So we will just allot the names and display the cases once again. So can we
I'm
go on with the allotment?
allotting I'm allotting the names now. Okay, I guess just a minute. Just a minute. I don't
That's
know.
all right. I can go once again.
I am really sorry for the technical glitch. Give me just 2 more minutes.
Meanwhile, if anybody has any doubts in this particular round, you can feel free to ask us. Team AMSA and Team MSAI.
Hi, Prachi. Am I audible?
Yes, Avi, you're audible.
Yeah. So just the flow of events, like, would you be individually asking us to give our arguments for how long? How does how does the flow of events go for the finale?
Yeah, so the speaking time for every particular lawyer is actually 4 minutes. You will be given a 10 minutes of preparation time wherein you will have to sit down and prepare your list of arguments of what you're going to speak out, and you will have to present your argument within 4 minutes. And it is the very order in which it is mentioned, that is the NGO, the government, Dr. Mishra, and in this particular order we will go on with the people right after it is allotted. And after the end of 4 into 6, that is 24 minutes, we will be having the rebuttals for 5 or 7 minutes, whatever the jury seems fit.
Hello, I have a doubt.
Okay. So
Yes,
I guess
Ria.
the roles, yes, after Ria speaks, we have the roles assigned.
So, what will be the order of the roles going with their arguments? Will there be a toss again, or is there
It will be
already
the
decided
same
order?
order that is mentioned in the slide. So see, the NGO is the first one, so I think Pankhuri from Team MSAI will go first, and then government and Dr. Mishra, and in that order. Yes, Keegan.
Rebuttals are at the end. Oh, sorry.
I know it might sound a little bit comical, but I just went through the case and I just wanted to know who is Preetham Sharma and what is his role in this whole thing.
I understand. I think we can read the case again. In that scenario, Preetham Sharma is actually the surrogate decision maker.
Okay. Okay.
This Preetham Sharma is a distant relative who is out of connect, but they were listed as the surrogate decision maker in this particular salpingectomy case.
Okay, but just another thing, there was no consent asked from the surrogate decision maker because that is not mentioned in the case anywhere. Just clarifying.
In this case, actually, when it was listed down according to the actual judgment, we are assuming that the surrogate decision has been taken by this particular distant relative. So you would have to argue in their favor as well.
Okay. Okay, thank you.
So
Ria, do
I'll
you
just
have...
read out the.
Yeah, sorry, I have just one more doubt. I just want to clarify. So the rebuttals are after all of the arguments are completed, right?
Yes.
Okay, and the preparation time you mentioned 10 minutes. I think in the rule it was mentioned 1 hour be given for the whole preparation. Or did I
Yeah. Okay, so we were going to give you an hour, but then we had to give you a 20-minute break, and we are actually running short on time, so we'll have to go through this. I mean, considering that we've given you the case just now, so you can mold the arguments in your favor. Basically, you have to protect your particular client in this scenario.
Right now we have been given 10 minutes, and after that the argument start.
Yeah. In this particular order. So, displaying the case on the screen once again.
Just to clear, is everybody clear with their roles, right?
Okay, we'll take that as a yes. Okay, so we'll display the case once again. Madhuri Sharma, who is 18 years of age. She is mentally retarded and institutionalized. She is the daughter of a mentally retarded woman. Her name is Lata Sharma, who lived in the same institution and was herself the daughter of an illegitimate mentally retarded child. So the state-run institution conducted sexual sterilization by salpingectomy, that is the cutting of fallopian tubes where fertilization takes place, an operation that would not affect her general health. This was conducted by gynecologist Dr. Mishra at his nursing home, and an NGO, Mahila Samiti, sought to move the court against this act, arguing over Article 14 of the Constitution. And Preetam Sharma, even though it has not been mentioned in the case, we have listed them as the surrogate decision maker for this particular case, considering that there are 3 generations of mental retardation. So we will start your time. I think it is 8:30, and we will resume sharp at 8:40. And the case can be here on the screen.
Can you just please inform what order you'll be following for the presentation of arguments?
Yeah, this order.
All right, great.
Can you just tell me again what time we are re-assuming the process?
8:40 p.m.
Okay, thank you.
Meanwhile, if there's anybody here from Team Simza and Team Rotaract Club of the Caduceus who would like to say a few words on how they felt about the debate, or if they want to discuss anything further, please feel free to unmute yourselves.
Hello, I'm Sneha from RC Caduceus team, and I would like to share my experience. So, this was a very new experience for me, and diving into the technicalities, legalities of all the case with respect to bioethics. It was a fun learning experience, and we are very grateful for this opportunity.
Thank you very much, Sneha.
Thank you so much, Sneha. And we really, yeah. I think Samyukta also has her hand raised.
Hi, yeah, I would like to say something on behalf of SIMSA. Right, so I'm very grateful to MSAI for giving us this opportunity and for dealing with the last minute replacements of the participants. The Moot code is a very, very new concept to us. Honestly, I was just like dumbfounded when we received the email. We were like, what is this? But I'm very glad that MSAI, Prachi especially, who dealt with all of my doubts and, guided me through the process. And I'm also very thankful to my teammates. I have wonderful teammates, and I think it's the best part of working in a group effort when all of them puts in equal effort, and we give our best, and there are no regrets about today. I'm very glad that we all participated, and I wish all the very best to MSAI and AMSA for the finals.
Thank you very much, Samakta.
Thank you so much, Samyukta. Likewise, it was very, very enriching for us to have this. And thank you so much. Sumaya, do you want to go ahead?
Am I audible?
Yes, you're audible.
I want to say that this was a really great learning experience for me, as the concept of a moot court is really new. And I was very, I would say, scared and afraid at some point about it, but then it really turned out better than I expected it to be. And it's just great seeing bioethics units from all over India come together and uh, have this competition. And I'm really looking forward to more competitions like this where we get to learn a lot from others as well. Thank you so much for this opportunity, and best of luck to the teams in the final.
Thank you so much, Sumaya. I think we can have one or two more. Just to remind all the participants that these are the last 3 minutes for your prep time, and after that we will reconvene and begin with the first speaker, that is NGO, which in this case is Pankuri Sharma. Reminding all participants that we will reconvene back in 1 minute, and we will be starting with the first speaker. Okay, I think the time is up. Can we have all the participants back here? Please send in a plus in the chat box if you're ready with your list of arguments. Okay, just to ensure that there is a record of everything that you're saying, we will be taking minutes of every person who is speaking their arguments. So it will all be written down, and if needed, we can refer to it later on if we are scoring you. So please be mindful of whatever you're saying, because it will be in a written record. So just to clarify, the individual speaking time for every person is 4 minutes, and we will go in this particular order. And after all 6 speakers are done, we will have an open rebuttal round, wherein rebuttals will be directed to a particular speaker and not a particular team, because there are no teams here. So, Pankhuri Sharma, are you ready? Okay, your time starts now.
Greetings to the jury and the members of the court. I am Pankhuri Sharma, the counsel on behalf of the NGO that is the main petitioner in this particular case of Madhuri Sharma versus the state of Uttarakhand and others. I would first like to very quickly state the Article 14 of the Indian Constitution, because that essentially forms the basis of all of our arguments henceforth. Article 14 of the Honorable Constitution of India is one that states that no person shall be deprived of his life or personal liberty except according to a procedure established by law. So now we ensure that Article 14 establishes right to life and right to protection of personal liberty as non-negotiable fundamental human rights. So if that is the case, then we'd also look at our specific person in picture, that is Madhuri Sharma, who is a mentally retarded individual, and we still understand that the UN guarantees that all human rights will be applied same, all human rights will be similarly applicable to individuals who are not who are mentally retarded as much as possible. This also includes Medicare, rehab, guidance, economic security, and protection from exploitation, which was clearly violated over here. So we cannot deny all of these rights to our plaintiff without any actual valid legal reason. We also understand that the mental retardation is only speculated to be genetic by the defendants. They're speculating that it's a genetic problem, and if in case there were results, why aren't they presented to the surrogate decision maker or to the doctor of the government institution? Why was a private practitioner sought to undergo the sexual sterilization procedure? Now, we also understand that it was mentioned that there was no harm to the general health of our patient, but we understand that in any medical procedure, there is obviously a risk of complications involved, and considering that our patient may not have been able to take care of herself better, there may have been complications in the procedure as well. We also understand that the United Nations, according to the Yogyakarta principles adopted in Indonesia in 2006, very explicitly states that forced sexual sterilization of any nature amounts to torture, and this is the exact wording of the document. So is this the 1920s? Are we Hitler? Is this the Holocaust? Are we ready to select which human lives are worth saving? Are we ready to select which person is fit to breed and which person is not fit to breed? That this is exactly why the United Nations has the Declaration of Human Rights in place. We also understand that as per medical ethics, Dr. Mishra was completely in the wrong he should be prosecuted under section 350 and 351 for criminal assault. He also violated the principle autonomy and consent according to the UN Declaration of Bioethics. And also the state of Uttarakhand cannot be absolved of the responsibility because the person was residing in their institution under their care. Also, we understand that the surrogate decision maker definitely had some malintent in his mind, because no sane person would agree to a forced sexual sterilization of a person under their care in such a case. With that, I would like to rest my case. Thank you so much.
Thank you so much, Pankhuri. And I guess let's move on to the next speaker. And the next speaker is the government on behalf of the institution, that is Tushar. Tushar, are you there?
Yeah, I'm there. Am I audible?
I guess
Am
is
I
it just
audible?
is it just me or is Tushar's voice breaking? It's breaking. Tushar, could you just repeat?
Just give me a second.
Sure, sure.
Am I audible now? Is it
Yes.
clearer?
Yes, it's perfect.
All right.
You're clearly audible. Okay, so your time starts.
It just
Okay. So let me know when you're ready and
so
I'll start.
I'm ready. You can just start the timer.
Okay, start.
All right. So greetings everyone. I'll just move on directly to my arguments because that's what your let's just cut to the chase. So first of all, I'm the counsel for the government. When we're debating on such ethical issues such as this, I would like to remind the NGO that assuming that all ethics would be followed is a utopia. And if you think that this was some sort of malintent, then also confining a mentally retarded patients in a separate place is again not ethically correct. But why are we doing it? According to the law, there are reasonable restrictions to the right of freedom, right to personal liberty, when public health and public order are considered at a larger level. So when we consider ethics, we do not consider them as boundless entities which cannot be contained. Secondly, when we're seeing this case, most of the people are all only considering that there is a line of illegitimate children, and they're considering it to be a genetic factor. That aside, we should also consider the fact that in such institutions such as this one, where the person is incapable of is mentally retarded, medically retarded, and is incapable of providing an informed consent, cannot judge the circumstances, is itself as becomes a victim of a lot of exploitation, which includes sexual exploitation as well. So when we're considering bioethics here, then I think the ethic of having a good quality of life is also important. A person who cannot provide consent for the act of coitus is also a victim of rape, and putting the body through another abortion or 9 months of pregnancy in such a state will put the fetus at risk again. So for the sake of beneficence, this act was carried out. Thirdly, equality does not mean that you keep everyone on a simple pedestal. We have moved on from the concepts of equality towards the concepts of equity and justice. When we are considering the classification, Article 14 itself has Article 15 itself enshrines that there is no discrimination, and reiterates on Article 14 that there can be classification of subjects. That was exemplified in Ramakrishna dilemma versus the Justice Tendulkar case of 1958, that classification can occur when public health and order are considered. Hence, in this case, the mentally retarded patient can have a different set of rules and standards to which he or she can be treated by. Thirdly, the NGO stated again that, and I quote, definitely had malintent. I do not see that the unquote. I do not see that the NGO is producing any hard evidence to prove that there was malintent. Malintent would be proved if you were a psychologist, if you had a medical board that had carried out a thorough proceeding to evaluate whether the doctor had malintent or not. Your arguments are also purely based on speculation. The procedure was carried out within the legal boundaries of considering what is in the best interests of the patient. The surrogate decision and if informed consent cannot be taken by the patient, the surrogate decision was made within legal and ethical boundaries. I do concede that ethics are limited by law, but this act was lawful. Hence, there is no violation of Article 14 or any gross violation of Article 14 in this case. Thank you. I yield my time.
Thank you, Tushar. Okay, so moving on. The next participant is representing Dr. Mishra on behalf of the Mishra Nursing Home, Abhi. Abhi, are you there?
Yes, I'm ready.
Okay, so you can start in 3, 2, 1.
Hi, everyone. Good evening. I represent Dr. Mishra, who, understanding the law, performed the salpingectomy of Madhuri. I would want to start by introducing and paraphrasing two important papers, starting with in 1987, the law Lords authorized sterilization of a 17-year-old girl with severe intellectual disability and epilepsy in her best interests. In the same year, they also ruled that it was not even unlawful to terminate the pregnancy of a woman with severe intellectual disability. The important thing I want to mention is we've moved on from this aspect, but we've moved on to a much more recent paper by something from the University of Washington, Seattle by Douglas Diakema, which states, while other less permanent forms of contraception might be acceptable, involuntary sterilization ought not to be performed on mentally retarded persons who retain the capacity of reproductive decision making. I am paraphrasing what should not be done just to give logic to my point. So that's one, who do not have the capacity for reproductive decision making. Secondly, capacity to provide valid consent to marriage. Mentally retarded persons should be considered for involuntary sterilization only when it would serve the best interests of the mentally retarded person. Less intrusive and temporary methods of contraception control are not acceptable alternatives. I am going to very systematically tell you now how this act was not only just not unlawful, how it did not just not violate any ethics, but rather supports three very important pillars of ethics. Firstly, the patient very logically is incompetent, so the question of autonomy does not arise. Secondly, very important, it is not that she's mentally retarded. She's severely mentally retarded, so absolutely makes no room for making decisions for decision making. So that comes to non-maleficence and beneficence is how I would be addressing them. Very clearly, it has been stated this process does not affect her health. Rather, I would say it really encourages better health. Our purpose should not be just pregnancy and carrying forward the lineage. I'm against eugenic abortions, but our purpose is not that here. Our purpose and our focus should be improving her quality of life. And do we really think that quality of life is going to be improved if, God forbid, her body has to go through a pregnancy? There are other medical contraindications for pregnancy, like coarctation of aorta. So if you consider mental retardation just another medical condition, why cannot it also be a relative or an absolute contraindication for pregnancy? Lastly, how I want to tackle the case that how the consent was valid because the child is illegitimate and also the daughter of an illegitimate mother, making her the responsibility of the state. So rather than ignore intervening for the best interest, how is it not in the favor of society being progressive? I would also want to raise the issue how it was being mentioned that why was not a government person approached, only a private person was approached. Let me tell you, my friends, every private person who's practicing in the state of India in itself can anytime be called by the government to serve the government and the country, right? I would want to rest my case besides just telling how it supports the pillars of ethics in itself, besides mentioning equity as very beautifully summarized by the previous advocate. We've moved to equity from a concept of equality, so raises no question of violating Article 14 of the Indian Constitution. I would want to rest my case by saying that Dr. Mishra was only performing her duty as a responsible Indian, as a responsible doctor to the state. Thank you.
Thank you very much, Avi. Moving on to our next speaker, Keegan. Keegan, are you there?
Yes, I'm here. Am I audible?
Yes, you're audible, but I can. Is your camera on?
Yes, my camera is on.
Yeah.
Yes, yes. Sorry. I would just bring the video. Okay. So your time starts in 3, 2, 1.
Okay, good evening, everyone. My client, Preetham Mishra, happens to be a distant relative of the Mishra family and the current surrogate decision maker as appointed by the court. Now, coming to the prosecution and their remarks about my client, they said that there was malintent. Firstly, I would like to show intent by saying that do not refer to my client's relatives as people with mental retardation. The correct term would be people with intellectual disabilities or people with mental disabilities. Okay, so now that we have that out of our talking points, coming to the case at hand, Article 14, like the prosecution said, makes an exception for all scenarios acceptable by law. The patient Madhuri, a person with intellectual disabilities, clearly falls under the purview of the Mental Health Act of 1987, thus a capable and acceptable exception to Article 14. In this case, there are three generations of intellectual disabilities. In medical terms, this is something that would be likely termed as an inherited trait. Under that pretext, my client decided that sterilization was the next best step, and eugenic sterilization was the next best step to ensure the rights to the patient as mentioned by the government. Like the government already said, abortions and rape are not events that can be even easily spoken about, let alone experienced. I would like to ask the prosecution if they know what it feels like to be somebody who goes through that, what it feels like to be part of a family of somebody who goes through that. With that, my closing statement should include the fact of testamentary capacity. For that, a patient needs to be in compos mentis. That means in sound state of mind, which the person at hand, Miss Madhuri, was clearly not. Thus, under Section 89 of the Indian Penal Code, her next of kin, Preetam Mishra, whose very intent has been questioned by the prosecution here, took the decision to authorize the sterilization. With that, I would like to bring a closure to my statements. Thank you for your time and thank you for listening.
Thank you very much, Keegan. So moving on to our next speaker, that is Kritika. Kritika, are you there?
Hello, yes. Am I audible?
Yes, you're audible.
Okay. Let
So
me know
if
when I
you
can start.
Okay, so if you could bring your mic a little closer because it's a bit.
Is it
Yes.
fine now?
Yes, it's perfect. Okay, so I'm starting in 3, 2, 1.
Good evening, everyone. So I see that my client faced a similar scenario in this case that the Jews faced in Germany around a century ago. That is the eugenic sterilization. Was that an acceptable act? Why was it referred to a violation of human rights? Sorry. How can we argue on the fact that everyone agreed on? So you might be thinking, why am I even mentioning this? But everybody accepted that it was a violation of human rights. But why doesn't it apply on my client just because she's mentally retarded? But then what about her rights to liberty and right to life according to the Article 21? And as we know, WHO in 2019 mentioned infertility as a disability. So that means the patient, the NGO and the doctor, the mental hospital and the doctor went through, my client had to went through a procedure which resulted in disability of my client, which is completely violation of Article 21 and this the fact that WHO stated this infertility as a disability. According to Article 15, the government of India enjoins not to discriminate against any citizen of India on the ground, including the disabled ones, on the ground of religion, race, caste, sex, or place of birth. Here, as it is clearly mentioned that the genes might be the cause of the mental retardation. So that technically means the race. So how can we not talk about Article 15? What about the right of my patient or on about the autonomy over their body, right to personal liberty? And I really want to argue and want to cross question the other team members. Why was the surrogate not taken a decision? Why was surrogate not included in the decision making process? I agree my client is mentally retarded, but surrogate could have been approached for a decision, but which wasn't done. And the chapter 7.16 of the Indian Code of Medical Ethics, the failure to obtain one is considered deficiency in discharging the duty. So there was a violation of this act as well, because the informed consent cannot be taken. Also, Article 3 of the Human Rights states no one shall be subjected to torture or to inhuman or degrading treatment or punishment. Sterilization without the consent is clearly the degrading treatment for my client, and hence the Article 3 of the Human Right was violated as well. every person, including the disabled, has his life and liberty guaranteed under Article 21 of the Constitution, which I clearly see getting violated. I hence therefore plead the jury to charge the mental hospital and the doctor on the basis of Article 15, Article 3, Article 21, Chapter 7.16 of the Indian Penal Code of Medical Ethics, as well as the decision of WHO considering infertility as a disability. Thank you.
Thank you very much, Kritika. Okay, so moving on to our last speaker. So our last speaker is Ria, who is representing Lata Sharma. Okay, so Ria, are you there?
Yeah, I'm there. Am I audible?
Is it just me or is Ria's voice breaking a bit?
Yes, Ria's voice is breaking a bit.
I'm back, guys. Am I audible now?
Yes.
Better?
Okay. Yes, it's much better.
Can I start?
Yes, you can start in 3, 2, 1.
Greetings to the honorable jury, my fellow clients and the respondents. I'm speaking on behalf of my client, Lata Sharma, who is the mother of the appellant of Madhuri Sharma in reference to this case. First of all, I would like to bring the point that it was mentioned that the mother, Lata, my client, being the illegitimate mother, her opinions don't matter, her preference does not matter, but I do not think right. Giving birth should be enough to speak in support of the patient, because it is a genetic condition. It has been spread, it has been passed on because of my client, hence her opinion should matter, and she should be able to give her opinion on this. Second, there is no mention of the severity of the disability. We don't know if, despite having the proof that we have had the disability passed on for 3 generations, there is no proof that it can pass on to the next generation at all. Unless there's a detailed study done on genetics, unless there's a whole family tree made, a study on each of the traits made, that yes, by for sure the trait is going to be passed on to the next generation.
Is it just me or is Ria frozen? And I'm also not able to hear her.
Yes. Yeah, we cannot
Okay,
hear
she's
Ria.
facing some technical issues.
Hello, am I audible now? I'll switch off my camera then. Hello.
Rasham, is that fine?
Yes, you're audible now.
Okay, I'm so sorry for
Yeah.
the inconvenience. Yes. As I was saying, there is no proof that disability will be passed on to the next generation unless there's a complete study done. A proof is mentioned, but I do not think there is any proof of that. Secondly, I would like to say that there is so much proof that I can provide stating that the sterilization against the patient is completely illegal and offensive. Currently, UN has recognized forced sterilization of a person with disability as torture, irrespective of its legal nature. The enforced sterilization is classified as a crime against humanity under the Rome Statute of International Criminal Code, and stating Indian examples. Presently, they are guided by the Convention of Rights of a Person with Disabilities. Under that, Article 16 states that the state party is liable to take all appropriate measures to protect the persons with disability. I do not think my client's daughter was protected at any cost. Her opinions were not asked at all. Additionally, Article 23 asks the state parties to uphold the rights of the person with disability to decide freely and responsibly on the number of spacing of their children, and to have access to age-appropriate information. Reproductive and family education are recognized as means necessary to enable them to exercise these rights. Was the client's daughter given this information? Was she given the chance to choose does she want to have a birth or not, even if she is mentally competent? It was the mental hospital's responsibility. It was the state's responsibility to provide her with the information first and only then proceed with this. Also, I would like to mention the point stated before about eugenism. It is not right to assume that causing sterilization of my client's daughter will stop the disability going ahead, and Eugenics of this kind is completely unacceptable and should not be justified. Dehumanization of people with developmental disabilities was widespread back then, but not now. Disabled people are vulnerable, they are discriminated against, and I feel this case should be strongly taken to avoid, to support and fight for those who are vulnerable and disabled. That's it. I would like to rest my case.
Thank you very much, Ria, and thank you to all the participants for presenting the points. Dr. Chef, shall we move on?
Yes, sure.
Shall we move on to the rebuttals? And
Yes.
I would just like to confirm the time for the total time for the rebuttals and the time per speaker.
I think for this session, we can go on with around 8 minutes. And
8 minutes?
yeah, and we can have 40 seconds for question and 40 seconds for answer.
Okay, 40 seconds for question, 40 seconds for answers, and 8-minute total time. Okay, thank you, sir. And sir, we'll be allowing sub-rebuttals as well, right?
Yes, yes. We'll allow 2 cross-examinations this time.
2 cross-examinations this time. Okay, sir. Noted, sir. Okay, so and before we begin with the rebuttal round, we'll be following the same procedure. You will need to raise your hands and I'll be calling out names. And before you begin your question, you will need to speak the role or the name of the person whom you're addressing. So that's important. So please keep that in mind as well. Okay, so moving on to the first person who has raised his hands, that is Ria.
Hello. Yes.
Yes,
I'm
you're
audible,
audible.
right?
Yes, you're audible. When I say 1, I'll start your clock. Okay, so your time starts now.
Yes. So my question is to the institution in which Madhuri Sharma. Despite, yes, my client's daughter was mentally ill, she could not make a decision for herself. But why wasn't the surrogate decision maker asked? Why wasn't their opinion?
Is it just me or is Ria not audible?
Okay.
I guess it was audible to me.
Yeah, it's audible. It's audible.
Okay, yeah. So my question being to the institution.
Okay, so sorry.
Despite the availability, a surrogate decision maker available, why wasn't he asked for opinion? Yes.
So the institution, would you like to reply?
Can you just display the case once if it's possible?
So I want to see the case once again. Just a minute.
Right. Just want to verify some facts.
Sure. Is the case visible now?
Yes, it is visible.
Yeah.
I guess let's begin because we do not have name.
Sorry, I just wanted to verify a fact. First of all, know where it is. All right. So I would like to answer to Ria. Basically, the onus of an illegitimate person goes to the next of kin, right? But for such a long time, the person has been living in an institution that it falls on the government to care for her on her daily basis. Secondly, the access to the next of kin is also important in such cases because we have seen in many cases throughout history that people abandon as such in people, and even if there is next of kin, they do not respond or are not available at the time of need. So when we are considering someone's quality of life, we cannot wait around on phone calls and not take action. Sorry,
Permission to reply.
Dr. Schiff, do we have the permission to reply?
Yes, we'll allow 2 cross examinations if they want to do it.
Okay.
Yes.
Yeah.
Okay. So you mentioned that in case of quality of life of Madhuri Sharma, here the sterilization does not assure quality of life for Madhuri Sharma, and sterilization is a huge procedure, a huge step, and even if the surrogate person, decision maker was not available, efforts should have been made to make him available and get his opinion no matter what, because sterilization is such a huge step. It is considered torture. It is considered offense by so many proofs that I've already provided. So I feel the surrogate decision maker, no matter what, should have been called for, even if he was not available at the time or was not available for
and time's up. Sorry to interrupt, your time's up.
All right, can I?
Yes, would an institution director like to reply?
Yeah, I will.
Okay, sure, your time starts now.
First of all, the basis of your argument rests on the fact that we did not do anything to contact the next of kin, where you failed to produce the evidence for the same. There is no such mention that we did not do any efforts. There is no such mention that there was no effort carried out to contact them. Was there a reply? Was there not a reply? So your entire argument is resting on a speculation that the government is incompetent. Secondly, all procedures were followed during this practice. It was not an impulsive decision that one day we woke up and we thought that we were going to carry out this procedure. All legal methods and avenues were sought after, and only then this was done.
I'm sorry to interrupt again, time's up. Okay, so moving on, we have the next question. The next rebuttal is from Keegan. Keegan, your time starts now.
Thank you. This is to the lawyer of Lata Mishra, the counsel of Lata Mishra. Firstly, I would suggest that the counsel of Lata Mishra pay attention to the arguments that have been presented till now. The surrogate decision maker was asked, and I had presented a whole 2-minute speech on why my client took the decision that was taken. Secondly, the counsel of Lata Sharma kept saying that the UN says something, but it does not. In the court of law, you cannot state what the UN says. It is about what the law of the land is. And the law of the land here very clearly states that the next of kin will be asked. And in this case, the next of kin was asked. And when they were asked, the next of kin gave permission for the sterilization. And the counsel also said where she was not given the option or choice. I would like to ask why. What is the option or choice to a mental patient? Sorry.
Okay, so would the respective lawyer of Lata Sharma like to reply?
Yes, I would like to reply. So,
okay, so your time starts now.
Yes. So, Preetam Sharma's lawyer, you have mentioned that you're present here and you've given your reply. But the sterilization has already occurred. During that time, you were not present to give your opinion, right? And in fact, it does not state that anywhere that the surrogate decision maker was brought and asked to give his opinion. You have stated your opinion right now, but sterilization has already occurred. At that time, the surrogate decision makers' opinions were not taken.
Can I just answer that if that's allowed?
Yes, sure. Yeah, sure.
As I said in my first presentation as well, the surrogate decision maker's decision was taken prior to the sterilization, even if it's not in the case. This was something that was very well clearly clarified before the case started, where there was an exchange between the moderator, Prachi, and myself, and a little more clarity was got on that. And even in my case, I have mentioned multiple times that I have taken my client has taken the decision prior to the sterilization. So that point, I don't think stands any ground then. Thank you.
Okay, so moving on to our next rebuttal, that is Pankuri. Pankuri, are you there?
Yes, I'm there.
Okay, so your time starts now.
So I'd like to ask the attorney for the surrogate decision maker. You very clearly put up a nice performative show of caring for your loved ones and your extended family and what all goes through to a person who's in this extended family. But these people have been institutionalized for 3 generations. Where were you when these people needed a family and a protective home? And why weren't you, as mentioned in the statement of facts, I agree, which was clarified later. But again, we understand the 3 generations of people that are institutionalized. Where were you then? Why were you turning up essentially at the point of eugenics?
I'm sorry, Pankuri, time's up.
Okay, if I can just answer that. Firstly, care and love does not need performance. I do not know why you think of it as a performative gesture, but it does not need performance. Secondly, I don't know the intent of your question. You question my intent. I do not know the intent of your question. Was it to show my client in bad light? Is it to show, because it has nothing to do with the case. The court of India appointed my client as a surrogate decision maker. There is no mention in any law that the surrogate decision maker needs to be involved in the life of the patient at all times. And that is exactly what my client done. So he was not involved at all times, but he did take a decision when it was asked of him. And I think that's all that matters here. Thank you.
So moving on to our next rebuttal, that is Dr. Avi. Dr. Avi, are you there?
Am I audible?
Yes,
Yes, very much there.
Okay. Yes, and I guess this will be our last rebuttal. And so,
Yeah.
Dr. Avi, you now have the floor.
All right. Okay, so respecting time very much, I'll like to keep it very simple, very short, directed to the attorney of NGO. To very simply answer me, do you actually think that allowing pregnancy in such a person is in the best interest of the health of the person involved? Actually think that? That's the question.
So would the attorney like to reply?
Yeah, definitely.
Okay, so your time starts now.
I'd just like to state one thing. In which condition are you saying that having a person who's not sterilized will 100% get pregnant? It is the duty of the state, the institution, and our surrogate decision maker, extended family, to safeguard our client, because we need some extra support and guidance from exploitation, that is pregnancy. That does not mean we push them into another torture, that is forced sexual sterilization. So I think that counters your point, in my opinion, because we are not saying make more babies, but we're also not saying make them disabled in a way. Thank you.
Okay, so time's up. Dr. Shiv, I was wondering if we could take another.
I would like to.
Okay, sorry, Avi.
Hamza, I think we can allow cross.
Can I sub-rebuttal to that, because
Hamza,
so I would really want to.
1 minute, Avi, 1 minute.
Shiv.
So the last
Yes,
rebuttal
yes.
that we did, we can allow cross-examination on that, and that would be the end of it.
Okay, sure, sir. Yes, Avi, you can go ahead now.
I would like to answer that by a very simple analogy. Not every BRCA positive female is supposed to 100% get a cancer, but she still prefers to get an elective mastectomy, right? Also, I would also want to tell you, how do you say that it is a torture to the patient? We are not removing the ovaries. We are not depriving her of any estrogens or hormones in her body. Do you actually expect this patient to get pregnant? And if your answer is no, why is an active intervention worse than actually not doing anything and sitting neutrally at the back? The state is actually showing responsibility by doing something in the direction that is required.
Can I answer this question, as I am the representative of the victim itself?
Dr. Shiv, we have the permission.
I mean, I would consider this as part of the cross-examination, but then this would be the last answer that you have. So choose carefully.
Okay, I would go ahead.
Okay, so Kritika, your time starts now.
Okay, so as you can say, you said about the fact, of course, we are not saying that we want them to get pregnant, and getting pregnant did not anyways harm the mother, because Mrs. Lara got pregnant with Miss Madhuri. So that anyway did not harm Miss Madhuri. So there was no harm in Lata getting pregnant. So that was her right to get pregnant as a woman, as a human right. It was clearly a human right violation and an act to disable my client. Thank you.
We'll end it here.
Okay, thank you, sir.
Yeah.
So it was really a great round of rebuttals and cross rebuttals, and I guess the audience, as well as those all who are watching on YouTube, really enjoyed the session. Okay, so now, Prachima, are you there? I am not able to hear you. And also, I guess she's facing some connectivity issues till the time. Dr. Shiv, could you please give your valuable comments on the finale?
Thank you, Hamza. I think it was again very heartening to see the efforts that you have all put in understanding this case, and definitely let me be very frank. Because I was judging the event, I did not want to influence any of your opinions. So I preferred not to speak anything when, even in the semifinals and now in the finals. But then we have to essentially take a note of a few things that have been going on. Repeatedly in the semifinals as well as the finale, we have seen the need to understand the provision of paternalism that we have in public health, which deals with provision of certain flexibility when it comes to implementation of ethics. Now that need not be at the cost of the individual autonomy as we usually think it is. So let's look at a simple thing about, like, even in this case, if we are talking about a mentally retarded person getting pregnant, if we are looking at this case through the eyes of the government, it looks to me like a case of paternalism, where the government is taking a step in terms of giving a positive outcome to the life that this person is going to live. But at the same time, we will always have an argument of individual autonomy, because that is how it is. For paternalism, always the one argument that stands in the way is of autonomy. But here again, we need to understand a few facts that we have here. So when you're talking about a person who is severely mentally retarded, there needs to be a basic understanding of something beyond the individual autonomy, because we are also supposed to look at the theory of utilitarianism, right? As well as we have to look at theory of beneficence as well as non-maleficence. See, none of the decisions that you made today as advocates of all these different people, none of you can base your decision entirely on one pillar of bioethics. It has to be a mix of a healthy blend of all these pillars. And somewhere down the line, we will have difference of opinions, because that's what ethics is about. Okay, we are going to have difference of opinions. If, let's say, if this was a case that maybe I was genuinely judging in the court, then I might have to say that I think it's okay if the sterilization was done, because to a large extent, if we look at the case very minutely, I mean, see, the case is given to you as a short summary of what has happened. We do not know the very the intricacies of what has happened. For example, the way we saw, there were certain questions where we were trying to understand why the surrogate decision maker was used in this case, and there might be some malintent, right? We cannot rule that out. Of course, we cannot rule that out. But at the same time, we do not know what has been done and what was the process that was taken while this case was with us. We do not know what background processes happened in the actual case. So I think if you look at this case as a case that was given to us, it might still be under content. I mean, I would be fine with allowing this particular termination of all the procedure that was done with this mother. But at the same time, whenever we take such decisions, the real safeguards that we need to place is this kinds of deliberations and discussions, because we need to make sure that there are people who are going to question you, okay, whenever you are going to decide in these areas. So very well, it might be a possibility that, because I also agree with one of the points that was raised, that so she was a daughter of an illegitimate mental retardation. So, I mean, she was also a product of victimization, I would say. I mean, if we are taking this step now, if the government is taking this step now, government is equally answerable of not being able to provide the safety that that lady was supposed to get when she was at that NGO. So these are the questions which will constantly come up, okay? And I think there would never be any right or wrong answers to this. We'll always have to deliberate, and the decisions that happen are usually happen in the context of that situation. Okay, so that becomes very important to understand. Mostly, be it the NGO, the government, or whatever the points that you guys have raised here today, it will always matter it will always matter to you when you are going to take that decision in a particular situation, and that is all that matters, right? So let's not think of these cases as what might be the right way to approach this, but then this is just a direction. So the discussion that we are having is a direction in which we need to frame our opinions and decisions, because somewhere you will always have a guilt of because right for me might not be right for you, right for you might not be right for me. So yeah, we have to understand ethics is accepting difference of opinions and still going ahead with a decision that needs to be made at every step of life, right? So yeah, I think that was my analysis of what has happened today, and I'm really impressed. I mean, the way you have analyzed the situation given the time that you had, it is really amazing to have all these inputs. Also, I would like to emphasize on a lot of times, see, when you will see the results, you might not actually be able to gauge how things have turned out. But you need to understand. I mean, the mere format of this competition was really amazing, because in the first round or the semifinals, you were being assessed as a team, right? And here, your individual performance is being assessed for the team assessment. So it sort of changes the dynamics a lot. It depends on how each of you performed individually, which was not the case in the previous rounds, right? So yeah, so whatever the scores are, whatever the final results are, I think each one of you have done really great, and I am actually looking forward to more such events. And yeah, we should do this more often, I think. Maybe take turns organizing such events. Different organizations take turns, and let me know if, okay, so this time I was approached for being a judge. Next time I would also, I can help you coordinate with many more organizations and bring, like, let's do it with like 10 or 12 organizations together. And I mean, this might be a good platform to, even promote a little bit of solidarity in different organizations that we are part of. So yeah, it was a wonderful initiative, and it was an absolute pleasure being here to see this event in total, and getting this opportunity to judge this. The only heartache is that I cannot announce all of you as winners. So that's just not in my hands. And yeah, so that would be the only heartache of being here. Otherwise, it was a wonderful experience. Thank you, everyone.
Thank you, sir. And I guess all of you are also tired from all this debating, rebuttals, and cross-questioning. So let's take just a 5 minutes break, and everybody drink water. And that's all. And after 5 minutes, we'll announce the final results. And once again, thank you, Dr. Shiv Joshi, for your enlightening words. And let's take a 5 minutes break, and we'll meet at 9:33 sharp. Okay, it's 9:28 now. We'll meet at 9:33. Hello everyone. I guess it's 9:33 p.m. So let's convene back. And do we have representatives from Team MSAI and Team AMSA? If they could put their representation in the chat box by a plus sign. Okay, so we have AMSA and MSAI both. Okay, thank you very much. So over to you, Molly ma'am, to announce the results. The President of Medical Students Association of India.
Thank you so much, Hamza. A very, very good evening to all the participants, to Dr. Shiv present here, and to all the organizers of the competition. My name is Dr. Molly Mehta, and I'm currently serving as the President at Medical Students Association of India. It gives me great pleasure to finally conclude the Moot Court competition for today. As already briefed in the beginning, this was the first time we conducted such a competition, and we were more than happy to see everybody getting engaged in the debates and the respective arguments which everybody made. And we hope that this helped you in terms of gaining more perspective, gaining more understanding, and we were more than happy for Dr. Shiv to help us throughout the process and give us his inputs from his end in order to make and learn from this in a better manner. Without further ado, I know that everybody has been waiting for the results pretty much, and I wouldn't take a lot of your time here. So just to before I announce the results, each team member was scored out of 300, and that made the total score of the total score out of which the one team was scored from 900. So each team has been scored out of 900 marks, and as Dr. Shiv mentioned, each team member was scored on the basis of the evaluation criteria which we had explained in the beginning. With that, MSAI has scored 645 out of 900, and AMSA has scored a total of 650 out of 900. So that brings us to the final results, and the winner of the Moot Court competition today is AMSA. Congratulations, Team AMSA. And congratulations to all the participants who participated for the Moot Court competition. The difference has been really, really close, and as Dr. Shiv mentioned, it was very difficult to do the final scoring, considering everybody participated so beautifully. So we really, really appreciate everybody's efforts for the competition, and we understand that it has been a long night for everyone to be present throughout the competition. With that, we come to the end of today's Moot Court competition, and I once again congratulate all the teams, team SIMSA, team RC Caduceus, team AMSA, and team MSAI for their efforts and for the hard work which was put in. Congratulations to both team MSAI and team AMSA to make it to the finals. Thank you so much. As I was saying, that like a special congratulations to both team MSAI and team AMSA to make it to the finals, and to put across the arguments in such a critical situation. We understand that the case wasn't very easy, but all the participants put across their arguments, taking into account multiple perspectives, which in itself shows how strong your concepts were, and how well prepared you were before you started off with your respective arguments. And with that, thank you so much, Dr. Shiv, for your time. We understand we've been keeping you here since quite a long time. So thank you so much again.
It was a pleasure. It was a pleasure. Thank you for the opportunity.
Thank you so much again. And with that, a good night. Take care, everybody. And thank you so much for your presence throughout the competition.
I would just like to thank the organizers. It was so very well planned, from everything. I know we had a lot of internet issues and these issues, and a varied amount of issues, but it was very well planned. As a participant, there was not one hitch that I had throughout the way. So thank you for being always so responsive. And to the participants, it was a pleasure and a privilege to compete against all of you all, whether it comes to CAD or SIMSA or MSAI. I think It has been an absolute experience to take part in this. Thank you. Thank you so much for allowing us to MSAI.
Hi, Pankri, can I say a few words? Sorry, so Hamza, am I audible?
Yes, you're audible.
So I am so sorry, I lost some network in there, but I just wanted to convey that I think it was the first time for a lot of us. It's not easy to get a new venture and get people interested, not even mentioning how you guys got 4 big names together. And more importantly, how beautifully it was executed, and somehow how different it was from a debate, how different it was from an MUN. And I think this is the next big thing. You've definitely nailed on getting it, making it big for the first time, and seeing all the great, amazing names. Like I can never have enough words for how Dr. Shiv Joshi has been appreciating and bringing things forward in such a beautiful way. So thank you so much for doing this, and congratulations to all the participants. I think it's definitely bigger than any victory or loss here. So it was a beautiful experience. Thank you for teaching us so much.
Thank you, Avi. Thank you.
Thank you so much. And I think Ria, would you like to go ahead?
Yeah, I just wanted to say it was an amazing experience. It was my first time in a moot court, and having debated with such wonderful people was amazing. And thanks to Dr. Shiv Joshi for providing us with constant support all the time. And whatever points you mentioned were really useful. And yeah, overall, I'm just really glad for this opportunity. So thank you so much, everyone. And congratulations, Hamza. It was amazing debating with you guys.
I'd like to mention it was really very difficult to score all of you, but Ria, you actually scored individually the highest. Okay.
Oh, wow.
So, so I just thought I'll let you know.
Thank you so much. It means a lot. It's my first time, really. It means a lot. Thank you so much, sir.
Great going.
All right. I don't see any other hands raised at this moment. So I think we can conclude today's meeting and call it a night. Thank you so much again, and good night, everybody.
Thank you, everyone. Thank you.